Sometimes we speak about, for instance, the bribe. Advocate Thulima Tonzela would speak about how sometimes people come out and they say, hey, government is corrupt, government is corrupt. But what about you as the individual when you're stopped by a police officer at a roadblock? What do you do? Do you also pay a bribe? Are you part of the problem in this constitutional democracy that we're speaking about? Once again, ladies and gentlemen, thank you so much for joining us this evening. To our listeners who are following the lecture on SAfm, thank you so much as well. For those who won't be able to follow on the radio, you can go onto our social media pages. That is at SAfm Radio. You can also go onto our Facebook page as well as our Twitter handle, and you can find the stream there live and follow the discussion that will be taking place this evening. I'm going to now call onto the podium the chairperson of the SABC board to come and introduce, or rather to come and welcome everyone who is gathered here this evening. And like the Chief Justice said during his lecture at the Nelson Mandela lecture in 2018, he said that you must ask critical questions of judges. Chief Justice, you're still a judge, right? And we can still ask those critical and difficult questions. So we can ask those critical and difficult questions. Ladies and gentlemen, let's welcome now onto the podium our board chairperson here at the SABC, that is Katu Ramokuma.
Good evening. I was reminded that this is a live broadcast, so I must be on time. So I think just quickly before I do the welcomes is just to thank the management of SAfm and the leadership at radio for this great initiative that we are launching here tonight. And would like to thank you very much, former Chief Justice Mogoeng Mogoeng, for agreeing to come and dig the foundation for what is going to be one of the many conversations, intellectual conversations, that we'll be having and hosting as SAfm and the SABC on contemporary issues that are facing South Africa. So just quickly to welcome you, former Chief Justice Mogoeng Mogoeng, and the family, your wife, your daughter, and the grandson. Also, I would like to thank Mr. Alistair Slinger from the Constitutional Court and the personal aid to the Chief Justice, Director Executive Support, and also to thank our panel of discussants, Melusi Kala, who is the Senior Researcher at Corruption Watch, Prelisha Singh, who is a partner at Weber Wenzel Law Firm, who is the head of practice there, and Kolelwa Kashe Katia, who is a project lead at Indulamiti as a Scenario Trust, all the guests who have accepted this invitation and honored us here tonight, the Director General of the Department of Justice and Constitutional Development, Advocate Dr. Mashabane, alongside senior colleagues from the Department of Justice, Advocate Lloyd Lotz, Mr. Selo Chulwane, and Ms. Khalalelo Masibi. Would also like to welcome the SIU's Mr. Kaiser Khanyago, and the Head of Stakeholder Relations and Communications, who's the Head of Stakeholder Relations Communications at the SIU. Would also like to welcome the President of Black Management Forum, Ms. Wongile Vilakazi, civil and social and legal organizations that are present here today, academic institutions that are represented here today, SABC board members who are here, and also joining us through the SAfm platform and all our other social media platforms, and as well as the SABC executive management, SAfm stakeholders, clients, partners, and commercial institutions, first citizens of the SABC, SAfm management, staff and talent, SAfm listeners who are joining us live in the auditorium tonight, listening on radio, and those who are streaming on our various social media. You are all welcome, and we look forward to an engaging conversation and informative conversation led by the former Chief Justice Mogoeng Mogoeng. Enjoy tonight. Thank you very much.
Thank you so much to the board chairperson there. We are now about to start with the inaugural public lecture. It's an SAfm public lecture. Once again, I'd like to just say a round of applause to the team. There's a lot of work that goes into putting something like this together. The other day, Bridget Masinga on Tuesday actually was saying that, hey, we're putting out fires as she was broadcasting. And she was saying that it almost feels like it is a Monday. And I said to her, I know how difficult Mondays are when it comes to live broadcasting, because you have to put all of that content together, but you have to put all of that content together also with shows like Bridget's show, for instance, over the weekend, and try to make sure that come Monday that you have a solid show. So our listeners don't get to experience all of the peddling that happens. You know, like when we speak about the duck that is peddling and peddling and peddling, but what you can see on the surface is all but serene. Sometimes there's a lot of difficulty, a lot of debate that happens behind the scenes, and disagreements as well that happens behind the scenes. But that is true to the nature of the institution that I'm proud to be part of, which is SAfm, which is, of course, as Umpatiwa would say, Station of the Year, PBS Station of the Year. Yes. Biggest talk radio station. Yes. And we hope that this time around, again, with the radio awards, we will come back again with the Station of the Year. Chief Justice, well, I keep on calling you Chief Justice. I don't know. I'm sure maybe other people do that as well, right? I'm sure that happens a lot. We are now going to call onto the podium the former Chief Justice of the country, Mogoeng Mogoeng. A bit later on, we will have a Q&A session. There will be discussions that will be taking place as well. So get your pen and papers ready. If you are typing out your questions, type those comments and questions. Keep them close to you, and we will come to you. And again, just another reminder that the Chief Justice at the time in 2018 said, ask difficult questions of justices, as we see that happen at the JSC. Chief Justice Mogoeng Mogoeng, former Chief Justice Mogoeng Mogoeng.
Thank you. Thank you very much. SABC Board Chair, Mr. Katu Ramukumba, Acting CEO, Ms. Lungile Binza, Radio Management, officials from the Department of Justice and Constitutional Development, listeners on radio, and all the people here, my wife, those that are on the prayer platform with me, good evening to you all. As stated, the topic for this inaugural lecture is Constitutionalism and Upholding the Rule of Law in South Africa. Has corruption and malfeasance eroded the moral fabric of the democratic dispensation in what is considered the world's leading example of a transformative constitution? According to my brief, I am at large to address any issue that is relevant to this topic, and may also share some reflections on issues such as the significance of constitutionalism in upholding democratic values, the role of the judiciary in safeguarding the rule of law, any case studies illustrating the delicate balance between individual rights and societal interests, the evolving nature of constitutional interpretation and its implications for modern challenges. Madiba's handwritten notes on the rule of law were reproduced in the book Dare Not Linger, written by Mr. Mandlalanga about Nelson Mandela's presidency. Here they are, open quote. I have to be bossy and establish that I obey the subpoena out of strength and not weakness. These two examples clearly demonstrated that in the new South Africa, there is nobody, not even the president, who is above the law, that the rule of law generally, and in particular the independence of the judiciary, should be respected, close quote. The two examples alluded to in this caution against untouchability are in relation to the subpoena to President Mandela to personally testify in the Pretoria High Court as a sitting president, and the Constitutional Court judgment that set aside the regulations he had promulgated on the basis that they were irrational. In each instance, he led by example and complied with a court order. At the tail end of the topic are two words: transformative constitution. They arouse a deep-seated yearning for the fulfillment of our shared constitutional aspirations. A failure to address transformative institution could otherwise denude this lecture of the real possibility it has of raising critical and burning issues that cry out for attention or a robust engagement. Additional to the essence of the rule of law already shared, it is necessary to first say what transformation and constitutionalism entail. Beginning with transformation, I'm in full agreement with Chief Justice Pius Langa's description of it as a social and economic revolution. As for constitutionalism, I again think it best to draw from the book Dare Not Linger. Quote him from his speech delivered when he inaugurated the Constitutional Court in February 1995. President Mandela said, I quote, "Constitutionalism means that no office and no institution can be higher than the law. The highest and the most humble in the land, all without exception, owe allegiance to the same document, the same principles. It does not matter whether you are black or white, male or female, young or old, whether you speak Setswana or Afrikaans, whether you are rich or poor or ride a smart new car or walk barefoot, whether you wear a uniform or are locked up in a cell. We all have certain basic rights, and those fundamental rights are set out in the Constitution," close quote. Transformation and constitutionalism are inextricably and purposefully linked and have converged into what has come to be known as transformative constitutionalism, about which Chief Justice Pius Langa had this to say, and I quote, "One of the central tenets of transformative constitutionalism is a commitment to substantive equality and improving socio-economic conditions. It is no surprise then that perhaps the biggest obstacle to attaining a truly transformative constitutionalism is the continuing disparities of wealth and power that pervade our country." Close quote. It is fitting, therefore, to want to know what progress we have made over almost 30 years of our democratic dispensation to address the continuing disparities of wealth and power in a meaningful way. This could be useful signposts with reference to which we have to measure our progress as a nation. But first, the constitutional architecture of our state. In the UDM versus the Speaker, the Constitutional Court addressed this issue with special reference to how the three centers of raw state power, the three arms, come into being and operate. It said, South Africa is a constitutional democracy, a government of the people, by the people, and for the people, through the instrumentality of the Constitution. It is a system of governance that we, the people, consciously and purposefully opted for to create a truly free, just, and united nation. Central to this vision is the improvement of the quality of life of all citizens and the optimization of the potential of each through good governance. Since constitutions and good governance do not self-actualize, governance structures had to be created to breathe life into our collective aspirations. Hence, the existence of the legislative, executive, and judicial arms of the state. They each have specific roles to play and are enjoined to interrelate, as foreshadowed by the following principle that guided our constitution-making process. There shall be a separation of powers between the legislature, executive, and judiciary, with appropriate checks and balances to ensure accountability, responsiveness, and openness. Knowing that it is not practical for all 55 million people at the time of us to assume governance responsibilities and function effectively in these three arms of the state and its organs, we the people designated messengers or servants to run our constitutional errands for the common good of us all. These errands can only be run successfully by people who are unwaveringly loyal to the core constitutional values of accountability, responsiveness, and openness. Since the state power and resources are for our common good, checks and balances to ensure accountability enjoy preeminence in our governance system. This is all designed to ensure that the trappings or prestige of high office do not defocus or derail the repositories of the people's power from their core mandate or errand. For this reason, public office bearers in all arms of the state must regularly explain how they have lived up to the promises that inhere in the offices they occupy, and the objective is to arrest or address underperformance and abuse of public power and resources. It behooves me, as a member of the judicial arm of the state, to address the proper exercise of state power in seeking to actualize our shared dreams. Courts bear the ultimate responsibility to give substance to the supremacy of the Constitution and the rule of law. They do so by, among other things, invalidating any conduct that is inconsistent with the Constitution and ensuring that constitutional obligations are fulfilled. Unlike before, they must rely on ideas and values. And as Chief Justice Pius Langa correctly pointed out, this approach to adjudication requires an acceptance of the politics of the law. There is no longer a place for assertions that the law can be kept isolated from politics. While they are not the same, they are inherently and necessarily linked, close quote. Judicial officers must guard against anything that could compromise their ability to bring an impartial mind to bear on the issues. I find this observation in the SARS versus Kruger case, which touches on the special role of the Constitution and the judiciary as well as the appropriate approach to issues to be useful. I quote, "The Constitution is the conscience of the nation, and the courts are its guardians or custodians. On their shoulders rests the very important responsibility of holding our constitutional democracy together and giving hope to all our people that their constitutional aspirations will be realized. To this end, when there is litigation about racial supremacy-related issues, it behooves our courts to embrace that judgment call as dispassionately as the judicial affirmation or oath of office enjoins them to, and unflinchingly bring an impartial mind to bear on those issues as in all other cases. Judicial officers must be very careful not to get sentimentally connected to any of the issues being reviewed. No overt or subtle sympathetic or emotional alignments are to stealthily or unconsciously find their way into their approach to the issues, however much the parties might seek to appeal to their emotions. To be caught up in that web as a judicial officer amounts to a dismal failure in the execution of one's constitutional duties and the worst betrayal of the obligation to do the right thing in line with the affirmation or oath of office. Although it was in a dissent, the Constitutional Court again addressed this matter. In the Public Protector versus the President of the Republic, it said, I quote, "Our laws must be interpreted with due regard to the foundational values of our democratic state and with a keen commitment to strengthening our constitutional democracy and furthering the constitutional project of ensuring that constitutional obligations are honored but not undermined or frustrated. The Constitution exists for the purpose of enhancing or enabling the attainment of justice, giving substance to our founding values, and ensuring compliance with high ethical standards and constitutional obligations. They are not to be interpreted in a way that impedes the realization of these critical objectives. Courts should not, therefore, inadvertently enable schemes designed to or that could unintentionally frustrate the fulfillment of ethical imperatives and constitutional obligations by allowing legal sophistry or technicalities to obscure commonsensical realities. It would obviously be remiss, if not hypocritical, of me to discuss acceptable judicial conduct but not touch on my own track record as a judicial officer. Admittedly, the JCC found me guilty, not of pro-Israel statements as far as was either ignorantly or maliciously propagated, but for criticizing the presumably existing official government policy towards Israel that was opposed to a peaceful resolution of the Middle East conflict and the attainment of peaceful coexistence. As it turned out, no such policy ever existed. That is the so-called involvement in politics that I had to apologize for. Hence the crafting of the mandatory apology in the terms that effectively reiterated what I had said before, including my love for both Israel and Palestine, as well as for the Jews and the Palestinians. As it eventually turned out, the Constitutional Court had this to say about the matter. I quote, "On a plain reading of the transcript of the webinar, the respondents' submissions are unsustainable. Interpreted objectively and within the context of the entire webinar, none of Mogoeng CJ's statements can be taken to be anything more than his religious and personal views, quite contrary to what the respondents argue. An objective reader would not understand the comments to be advocating for a particular political stance towards the conflict other than, at most, hopes for forgiveness, peace, and love. They do not intimate any kind of hostility or negative views towards any of the parties involved in the conflict. It is an untenable stretch to characterize Mogoeng CJ's comments as expressing unconditional support for the state of Israel, when the context quite evidently shows that Mogoeng CJ was communicating his biblical love for all, including Israel and Palestine, and his opinion on South Africa's painful past and unique perspective, which enables it to advocate for peace in the global context. There is also nothing in the evidence provided by the respondents which supports the notion that Mogoeng CJ condemned the BDS movement and South Africa's stance towards Israel. On the contrary, the transcript of the webinar reveals that Mogoeng CJ declined to comment on whether the BDS movement is conducive to a peaceful resolution of the conflict. In determining this inquiry, we have to assess the facts relating to Mogoeng CJ's conduct, not the media's interpretation thereof. On the contrary, courts must cautiously avoid being influenced by the media, for failure to do so would be the end of a functional and independent judiciary. The issue of recusal must be determined by taking stock of the objective facts, which can hardly be said to be found in the pages of the press. We are aware of no reason why anything in the media should have any bearing on this inquiry. We could very easily find ourselves going down on a treacherous rabbit hole if the media were to guide our objective assessment of the facts in cases that seize us. After applying the law to the facts, the only conclusion that we can reach is that the respondents have not discharged the onus of establishing that on the correct facts, Mogoeng CJ's conduct created a reasonable apprehension of bias, close quote. The next center of state power is the legislative arm, and constitutionalism and the rule of law demand of the National Assembly to hold the President and his team accountable in addition to its lawmaking responsibilities. The Constitutional Court again had occasion to express itself on this matter and the role of Parliament as follows. I quote, "The National Assembly, and by extension Parliament, is the embodiment of the centuries-old dreams and legitimate aspirations of all our people. It is the voice of all South Africans, especially the poor, the voiceless, and the least remembered. It is the watchdog of state resources, the enforcer of fiscal discipline and cost-effectiveness for the common good of all our people. It also bears the responsibility to play an oversight role over the executive and state organs and ensure that constitutional and statutory obligations are properly executed. For this reason, it fulfills a preeminently unique role of holding the executive accountable for the fulfillment of the promises made to the populace through the State of the Nation address budget speeches, policies, legislation, and the Constitution, duly undergirded by the affirmation or oath of office, constitutionally administered to the executive before assumption of office. Parliament also passes legislation with due regard to the needs and concerns of the broader South African public. The willingness and obligation to do so is reinforced by each member's equally irreversible public declaration of allegiance to the Republic, obedience, respect, and vindication of the Constitution and all law of the Republic to the best of their abilities. In sum, Parliament is the mouthpiece, the eyes, and the service delivery ensuring machinery of the people. No doubt it is an irreplaceable feature of good governance in South Africa. It was in response to these obligations and in order to address the demands of the socio-economic revolution that the Mineral and Petroleum Resources Development Act was enacted. As a result, some landowners forfeited ownership of their minerals in their land, presumably in pursuit of the preambolic aspiration of righting the historic economic injustices. This laudable objective was captured in these terms by the Constitutional Court. I quote, "South Africa is a geographically sizable country and very rich in minerals. Regrettably, the architecture of the apartheid system places about 87% of the land and the mineral resources that lie in its belly in the hands of 13% of the population. To address this gross economic inequality, legislative measures were taken to facilitate equitable access to opportunities in the mining industry. A delicate but admittedly very difficult balancing act had to be struck between individual rights and societal or national interests for the attainment of much-needed economic justice and a boost to economic development and growth. Our courts handled this balancing act as follows. I quote, "This brings to the fore the obligation imposed by Section 25 not to overemphasize private property interests at the expense of the state's social responsibilities. It must always be remembered that our history does not permit a near absolute status to be given to individual property rights to the detriment of the equally important duty of the state to ensure that all South Africans partake of the benefits flowing from mineral and petroleum resources. More tenderly, it could undermine the constitutional imperative to transform our economy with a view to opening up access to land and natural resources to previously disadvantaged people. This would also affect the need to create jobs, grow our economy by developing these resources in a sustainable way, and guarantee security of tenure to those prospecting for or exploiting mineral and petroleum resources. Consistent with the same imperative that birthed the Minerals and Petroleum Act, the interpretive exercise to legislation meant to advance the economic interests of all citizens was approached as follows." I think I must just pause to find out how much time I have left. I'm rushing. Wow. Well, let me skip all then rush to the end. The possibility of activating transformative constitutionalism and rule of law machinery and to ensure accountability, responsiveness, and openness lies largely with the fundamentals that inform how one gets to ascend to the highest position in a political party and, by extension, to the highest offices in the political arms of the state. Who facilitates a politician's upward mobility is a question that must necessarily and seriously exercise our minds. For the biting truth is that there is no free lunch in this world. Private funding of individuals in political parties and of political parties themselves is, in my view, an investment that is expected to yield very handsome returns as soon as beneficiaries thereof rise to positions of sufficient authority to deal out favors and tenders. And this is a well-researched reality, by mature democracies like the USA. Unfortunately, a compromised leader is most likely to compromise others as well. The objective being to disarm and immobilize those who could ordinarily have insisted on constitutionalism, the rule of law, and accountability. And that is how the moral fabric of a constitutional dispensation could be eroded. What follows was an attempt by a lone voice in the wilderness to awaken us all to this potentially devastating possibility, and I quote, "When people or entities other than the then Deputy President's party gave him sponsorship or financial assistance for the purpose of realizing his ultimate political dream, he was, by accepting help or allowing others to accept help on his behalf, exposing himself to a situation involving the risk of conflict. For that sponsorship or financial assistance to help him rise to the highest political office is most likely to induce a favorable disposition towards those who stood by him when help was sorely needed. And that is what the risk of conflict sought to be averted through these legal instruments or the duty to disclose entails. The reality is that private funders do not just thoughtlessly throw their resources around. They do so for a reason and quite strategically. Some pour their resources because of the policies of a particular party or independent candidate, because the policies of a particular party or independent candidate resonates with their world outlook or ideology. Others do so, hoping to influence the policy direction of those they support to advance personal and sectional interests. Money is the tool they use to secure special favors or selfishly manipulate those who are required to serve and treat all citizens equally. Unchecked or secret public funding, secret funding from all, including other nations, could undermine the fulfillment of constitutional obligations by political parties or independent candidates so founded, and by extension, our nation's strategic objectives, sovereignty, and ability to secure a rightful place in the family of nations. Our freely elected representatives cannot help build a free society if they are not themselves free of hidden potential bondage or captivation. The commitment to build a united and democratic South Africa and to improve the quality of life of all citizens can only be honored by public office bearers whose character or willpower is unencumbered. In circumstances where ethical leadership, transparency, and accountability are key to the survival or well-being of our democratic order, a state functionary may not permissibly choose a way to obscure an otherwise disclosable benefit by creating or allowing a structure to be created as a repository of a known benefit under the garb of a distinct juristic personality so as to escape or immunize himself or herself from a constitutionally prescribed obligation to be open, accountable, and to disclose. The foundational values of openness and accountability demand that we pierce through the trust veil that is capable of inadvertently or by design frustrating the all-important disclosure in this corruption-infested country. Why would anybody not want to know who is helping them and how reasonably practicable is that anyway? And why would they want to have their benefactors unknown to Parliament or the public? It bears emphasis that the refusal to know in circumstances where there is a duty to know and the consequential failure to disclose is a sure, albeit unintended recipe for corruption under the cover or facilitation of a well-structured mechanism or legal stratagem, again not intended to, but having the inescapable effect of evading accountability, openness, and disclosure. The President, therefore, had the duty to know, if he did not know already, who was funding his campaign, and to disclose that personal benefit compositely as a benefit from the CR17 campaign, as an entity and or more appropriately from each donor with a specified amount. Why? So that Parliament and the public could know who was helping or had helped him to perform better than his competitors and enabled him to become ANC president and a few months later, President of the Republic. The possibility of an unhealthy relationship with donors and the risk of conflict between the Deputy President's official responsibilities, as he then was, and his private interest as the enabled most senior political party functionary could then be closely watched to check whether the financial support had induced him or repositioned his disposition or heart to the point where his commitment to his constitutional obligations was in any way compromised, or his government's treatment of funders was more favorable than of those who did not fund him or gave less. This is what the foundational values of openness and accountability, as well as the regulatory framework properly understood, seek to address. Had it not been for the whistleblower who shared the emails with the public protector, it would most likely have never been known that the president and his campaign team presented facts known to be incorrect to the public protector. The president and the CR17 team chose to and represented to the public protector that he deliberately kept himself and was intentionally and strategically kept ignorant of the donors and the extent of their contributions to the campaign, as well as the operations of the campaign in relation to those financial contributions. The public protector subsequently got hold of and relied on emails that belie the president and the CR17 campaign manager's shared version of the president's professed ignorance. The president says repeatedly that he was not afforded the opportunity to be heard before the emails were finally relied on, that they were stolen or irregularly obtained from the CR17 campaign computers, and because they constitute improperly obtained evidence, that irregularity alone is sufficient to vitiate the entire report. The president effectively acknowledges the existence and admits the authenticity of the emails. He confirms that there are indeed communications between him and, among others, the CR17 campaign team contained in the computers of the CR17 campaign. He demands more than once that the public protector should explain to him how and from whom she obtained these admittedly truthful but reputationally damaging emails. Not once does he explain why he and his team chose not to tell the truth, but to rather mislead the public protector, as he did. Instead, he says that the emails are in any event irrelevant to the public protector's findings. But that cannot be correct, for not only are the emails relevant, but they also expose the falsehood of the version that the president and the CR17 campaign managers chose to present to the public protector. And it bears repetition that the false version is that there was a deliberate plan to ensure that the president does not get to know who the donors were, how much they donated, and how the financial assistance received for his campaign was being used. The emails squarely belie this assertion. The question that we should then be asking ourselves is, why did the president and his team deliberately convey a falsehood on an issue so crucial and inextricably connected to the constitutional imperative to promote and observe high ethical standards in obedience to the demands of our democratic state's founding values, openness and accountability? He must have known that if the truth evidenced by the emails were to be told, the obligation to disclose the names of the funders and the size of their contributions to the National Assembly, and by extension to the public, would automatically and plainly be triggered. And the public would then have the opportunity to curiously and vigilantly monitor the outward manifestation of his relationship with the sponsors. Because of the gravity of these reflections, it behooves us to be more specific and frontal about the relevant constitutional demands upon the presidency. The president, as a state functionary, is, in terms of Section 239 of the Constitution, an organ of state. And Section 189(3) of the Constitution demands of him, as an organ of state, to uphold and respect the Constitution by assisting the public protector and ensuring the effectiveness of that office. And that office cannot be assisted and its effectiveness ensured when those who are under a constitutional duty to help it choose to mislead it and to fight it to the end for exposing their untruths. What the president self-evidently did was to undermine and frustrate the efforts of that office to fulfill its constitutional obligations by not just withholding the truth, but deliberately asserting the opposite of it. Furthermore, the president is obliged by Section 96(2)(b) of the Constitution to not act in any way that is inconsistent with his office. This section is the constitutional source of the high ethical standards by which the president is supposed to lead this nation, strategically and intentionally giving a false version to the public protector while she is investigating a possible ethical breach falls squarely within the catchment area of this section. Lest we forget, we are not dealing here with an average citizen, but with the bearer of specific and frighteningly weighty constitutional responsibilities, who is expected and required to lead by example and be above reproach. His office demands of him to be the lighthouse, the pathfinder, and the embodiment of and the vessel for the enforcement of high ethical standards, particularly the constitutional values of our democratic state. In this instance, transparency, accountability, and the supremacy of the Constitution. Like all of us, he has rights, but unlike all of us, he does have special obligations, not imposed by the courts, but by the Constitution and legislation. It is the president, the number one or first citizen of the Republic, who we are talking about here. His is a distinctive and supreme office in the land that does not permit the employment of extraordinary technicalities when issues of ethics, transparency, accountability, upholding and respecting the Constitution have to be considered and pronounced upon. It is in this context that one is constrained to keep on saying that technicalities must not be allowed to easily frustrate the fulfillment of core constitutional obligations and the attainment of substantive justice. In conclusion, why does it look like we are failing or unwilling to resolve the all-important ESCOM issue? After all, it has been many years since those who were allegedly corrupt and destroying ESCOM have been relieved of their duties. The same group that actually ended load shedding at some point. Besides, this is not a new problem, and our future, our economy and credibility as a nation depends on the functionality and efficiency of ESCOM. I saw a clip of one of our businessmen complaining about how cheap the public obtains electricity from ESCOM and that it made it difficult for the private sector to compete with ESCOM. Is that clip real and true, or is it one of those maliciously manufactured campaigns against innocent people? It needs to be looked into, together with the explanatory note that goes with it. It bears emphasis that the resolution of the ESCOM problem is long overdue. This is a matter of constitutional office bearers and the state having to own up to their critical obligations, and our curiosity should extend to whether independent power producers are a blessing or a liability, including whether we, the people, are getting value for money from them. It is most devastating to have almost 7,000 of our people killed by criminals in 3 months over so many years. So many women raped, so much fraud and corruption in both the public and the private sector, runaway crime and lawlessness throughout the country, even when it comes to driving. To have our road and railway infrastructure in so deplorable a state, and to have to contend with this educational system that is beginning to look like institutionalized mediocrity. Where is consequence management? Who has been awarded big tenders by state-owned enterprises like ESCOM, Transnet, etc.? How much did they pocket? Who do they relate to, or who or what have they funded? And did we get the value for money from their actual or supposed services? What is being done about the toxic material reported by Al Jazeera years back to have been dumped by one of our mining companies in the West End, which has had a deleterious effect on the health of children and adults, animals, and vegetation. The engineer interviewed alleged that the affected mining company said that it would be too expensive to remove this hazardous material. Has it since been removed? What about those who have been dumping toxic material in our rivers and ocean? Constitutionalism and the rule of law demands consequence management under these circumstances, considering the provisions of our Constitution and environmental legislation. We have had a glimpse at the possibility of landowners deriving a semblance of benefit from the exploitation of the mineral deposits in their land from the Royal Bafokeng people. The recently renegotiated mining agreement between De Beers and the Botswana government and Uganda and the petroleum industry. Given the state of our economy and the multiplicity of our needs, is there anything stopping us from renegotiating and insisting on beneficiation like other nations? Do industries exploiting the mineral resources in our rural communities honor their disturbingly unfair social responsibility contracts? If so, where? Just how effective are the legal instruments and agencies established to contain the vulnerabilities and compromises that come with private funding? Is it not time that we develop a public funding model that would ensure that government and political parties owe their allegiance to the taxpayer rather than to private funders? Isn't it a price worth paying to avoid a democratic order that potentially or in reality produces a government by the rich, a government of the rich, by the rich, and for the rich? Should it matter that no other nation has ever done that? Why should we be copycats? Otherwise, let's consider an altogether different constitutional system which will truly yield substantive equality, including equality before the law and improve socio-economic conditions, thus doing away with the inhumane habitations like the Guguletus, Manenbergs, Kaelichas, Mitchell's Plains, and Deep Sluots that are seemingly spiraling out of control. President Thabo Mbeki produced a report on the unbelievably large scale of illicit money flows from Africa, which seems to be an existential threat to our economy. Who of the natural or corporate citizens of our country are involved in this, and what is being done to shame and punish them? If we don't know them, why? Who investigated them and when? Why and how did the current state of dysfunctionality get to settle in so comfortably and to the point of being normalized in the overwhelming majority of our municipalities? Where are the ethical leaders to stem this tide when the nation so sorely needs them? I recently heard, as I conclude, the director of the World Health Organization alluding to another COVID-like vaccination program. I also watched a clip of him being asked, I quote, "And you took your first COVID vaccination when?" After stuttering for a while, his response was that he didn't take it out of a sense of solidarity with Africa, because he is an African and most Africans were not vaccinated. So he who was pushing this vaccination agenda so hard against others did not avail himself for it. And I also hope that it is a lie, that health professionals here are hard at work in preparation for another vaccination project alluded to by the World Health Organization. If this is true, constitutionalism and the rule of law demands that a state of emergency, which is sourced from the Bill of Rights, be declared, so that our inviolable Section 12 constitutional rights can be respected rather than be taken away by some ministerial regulations. None of us is supposed to be subjected to medical experimentation without his or her informed consent. That is what the Constitution says. Notwithstanding some of the reportedly controversial statements he made, I still find this remark attributed to Elon Musk most thought-provoking. He says, I quote, "Imagine a vaccine so safe that you have to be threatened to take it. For a disease so deadly, you have to be tested to know you have it. It might sound simplistic, considering that as deadly as cancer could be, one often has to be tested to know that you have it. But you are never threatened or rewarded or forced to be tested, not even for HIV and AIDS. The foundational values of accountability, responsiveness, and transparency, which are the essential part of the moral fabric of our democratic dispensation, and are also embedded in constitutionalism and the rule of law, demand that we be not ambushed with some of these medical programs, chiefly promoted by personalities and entities whose genuine commitment to human rights and the alleviation of the suffering of Africans, like in Gugule to Kaelich, all these squatter camps, and other people in the rest of the third world, is not known. I apologize that I had to rush so much because I have been warned to stick to time. Thank you so much for listening. Where do I go, down or here?
This is the station of the year, SAfm, leading the conversation.
Everybody who is going to be called upon to take an oath or an affirmation is required to do so as allegiance to the Republic and obedience to the Constitution. I would rather die than be party to any corrupt machinery.
SAfm Inaugural Public Lecture, delivered by the former Chief Justice, Mogoeng Mogoeng.
When something is in the heart, you really don't need to be checking as if it was something that was designed to facilitate your appointment.
This is the station of the year, SAfm, leading the conversation.
Once again, a round of applause to our guest lecturer, former Chief Justice Mogoeng Mogoeng. I'd like to believe that he didn't fail in giving us thought-provoking nuggets to deal with and to grapple with, which we're going to open up a bit later on when we open up the Q&A session. By the way, those who are tweeting or Xing, please use the hashtag Mogoeng on SAfm. So that is hashtag Mogoeng on SAfm. A lot of issues that have been raised, but I don't want to deal with those issues. I'm going to leave them up to my colleague, Songezo Mapete, who is going to have a discussion with his panelists to speak about what came out of this lecture that has been delivered by the former Chief Justice, Mogoeng Mogoeng. And then after that, it is open up to you, as you can get the opportunity to ask questions directly to the former Chief Justice, Mogoeng Mogoeng. Songezo.
Aldrin, thank you so much for that. Former Chief Justice, good to see you. You look healthy, vibrant as ever. Good evening, ladies and gentlemen. Thank you so much for being here. My name is Songezo Mapete, and right on time, normally I would be on air at exactly 6 minutes after the hour, 8 o'clock on a Monday and Tuesday. Now that it is a Wednesday, I'm inclined to believe better things are yet to come. Do I see Andile? Do I see Shweshwe? Do I see Tony? Ladies and gentlemen, we've come to the session where now we will engage the thoughts of the former Chief Justice. We have members of the panel who, as they come up, I'll take an opportunity to briefly introduce them. Prelisha, please lead our guests on. Coming up on stage are Ms. Olelwa Kashe Katia, Project Lead, Indlulamthi SA Scenarios Trust. She's in the past worked as a research and project manager in academic, public and civil society sectors. She holds a BSc from UCT, a BSc Honours from Tuks, Pretoria, and a Master of Philosophy in Heritage and Public Culture from UCT. She's also an Honorary Research Associate at UCT's Archives and Public Culture Research Initiative. Ms. Pralisha Singh has a BCL from Oxford University, the year 2011. She has previously Justice Mogoeng clerked at the Constitutional Court in the chambers of Justice van der Westhuizen. She is now a partner at Weber Wenzel Law Firm. She's the head of practice in the public law sector with specialities in constitutional and administrative law. The final member of the panel is senior researcher at Corruption Watch with a specialization in human rights and corruption. His name is Melusi Ngala. He applies himself to the work that he does by tapping into his lived experiences as a blind black male whose social, societal views are informed by continuous engagement with diverse communities across the political spectrum. Much of his exercise or expertise and skill sets have been repurposed and honed for human rights related activities and anti-corruption work especially. Of the many things that he has done, his employment history in which he's filled various capacities include, among others, years at Corruption Watch and Wits University, as well as a stint at United Nations Population Fund Agency. These roles, among others, give testament to his versatility and adaptability as a professional, activist, and person living with a disability. In the 20 to 30 minutes or so that now shall follow, I will engage them in delineating some of the key features that come through from the former Chief Justice's speech and some of the contemporary questions that South Africa continues to battle with, questions that perhaps might be answered this evening, or questions on top of questions that remain unanswered. What is true is that South Africans are hungry. What is also true is that South Africans are in the dark. Hungry people in the room are dangerous, not least to themselves. A round of applause to the panelists as we're about to get rolling. Pralisha, Ms. Singh, thank you for being on the panel. I appreciate your presence here. The word that I came across, or the term that I came across for the first time, but of course it resonates quite well, is constitutional errands. Justice Mogoeng made mention of that. Constitutional errands to me implies that there's a constitutional actor running the errand, which errand is constitutionally sanctioned with powers and protections that come from the Constitution in pursuit of, for the fulfillment of, constitutional obligations, sanctified constitutional obligations, enshrined, that are the basis of South Africa as a society. And it's a consensus-based constitution. Do we have, from what you've heard the Chief Justice speak to, have constitutional actors who meet constitutional muster to run these errands, one, to deliver, implement, and have as a result the constitutional promise? Open-ended question, take it however you will.
Thank you, Songezo. And good evening, everyone, former Chief Justice in particular. Good evening, everyone. Thank you, Songezo. Thank you, former Chief Justice. I think it's quite important to let the viewers and those in the audience know that former Chief Justice let us in on his speech when you all heard it. And so we are delivering these thoughts off the cuff today. But thank you for a lot of thought-provoking things to discuss. Songezo, it's interesting to now conceptualize which constitutional actors you're referring to. The Constitution has a dense Bill of Rights with obligations placed on the state, obligations placed on the citizenry. But at the level of constitutional actors, it's important to bring it back to this idea, or the theme of today, being the role of corruption and its link to the constitutional project and whether that has been eroded. In our pre-discussion, I'd mentioned to you that corruption is not a new concept. It actually has been around from time immemorial. It's unfortunately perhaps embedded in our human condition. We do, however, have the most progressive constitution in the world, a very aspirational document that then defines parameters of obligation and of power. I think the issue is not whether we have the sufficient constitutional actors or whether we have the right systems, machinery, or laws. I think our issue sits at the level of implementation and at the issue of accountability. And for me, it's not so much do we have the right actors in the right roles. It is when those actors do not fulfill those obligations placed upon them, what is meant to happen and what has historically happened in South African
put it
democracy.
to you, that's a secondary inquiry to the primary objective of having constitutional actors being of constitutional muster, to act constitutionally. Put differently, in 2016, 31 March, we heard the same Chief Justice in the Nkandla judgment, among other things, say something to this effect. The President failed to protect, uphold, and defend the Constitution. If that were a judgment, his speech earlier this evening, in reference to that President's successor, the same language applies. The question is, how much then, in the context of constitutional actors, are we gleaning from this executive office personalities who attract commentary of the kind we have heard in an official capacity from the former Chief Justice and in a public lecture of the magnitude this is, given the fact that it's distributed nationwide, if not internationally? Constitutional actors forget the fact that they might not be held accountable by other constitutional actors. In fact, that in itself implies the constitutional actors who are there are not up to standard, are not up to meet.
Well, it then I think goes to at the point at which they reveal themselves. So do we have them in at the first instance? Perhaps no. Are we vetting them appropriately? Are we putting the right people in power with the right qualifications, with the right intent in place? I think that's questionable. I wouldn't cast it as widely as that exists at every office, but I do believe in some serious offices we've had questionable appointees. But for me, it's when they reveal themselves, because the most actors placed in, I think, would have the necessary qualifications at the point and demonstrate the intent. But it is at the point that they reveal that they then don't have, as you call it, the muster, that then something needs to be done. And I think for me, it sits at the level of done.
What needs to be done there, Melusi? What needs to be done? How do we hold constitutional actors who have, on the evidence of what the nation has been seized with, in a national rhetoric, national commentary, social, political, economic, we hear that there is malfeasance. The fact that this discussion is taking place is implicit in terms of the mood of the nation. We wouldn't be having a discussion that was isolated from the society in which it was happening. The fact that the conversation is happening, to me, implies that there is a problem. And perhaps in the context of constitutional actors running constitutional errands in pursuit of constitutional promises and obligations, to have a constitution that actually transforms lives. Melusi, what then do we as a society do? Surely it cannot be that we exercise the right to vote every 5 years and then leave it to the assumption that constitutional institutions are sufficient to beget us the constitutional results. Your thoughts?
I think that when you listen to the former Chief Justice's talk this evening, it was quite reflective, requiring us to be introspective. And dare I say, it came across as a judgment, right, on our society. And maybe it was necessary, because just to go back to the initial question that you asked about the actors, what did we do as a society, for example, when Marikana happened, right? It was a shocking event, something that we were well versed with. In fact, we saw it on our TV screens. And 5 years later, the ruling party then goes ahead and says this very same person who's implicated in this audacious crime, in one way or the other, right? Whether he's guilty or not, but by association, morally at least, is fit for purpose or fit enough to head that political party. And then we as a society, a year and some months later, go on and say, this person can indeed lead us as a nation. So it then, to answer your question, it then requires us to think deeply about, do our check and balances, are they sufficient at this point in time, right? We can now assess almost 30 years later to say that we've had the Chapter 9 and Chapter 10 institutions, we've had the judiciary involved in very complex cases, some argue that highly political and contentious cases, and we've had civil society also involved in these check and balances, but are they sufficient? That's on the one hand. On the other hand, what of our civic education, right? Do we have a society that is understanding our ethics as a people, what our moral obligations are, so that when we move ahead, when we try to exercise what's embedded in the Constitution, that we do so rightly, accountable, and transparently. I don't think that, especially in relation to civic education, in terms of how we talk about these issues, that we do actually introspect, and hence this particular speech was very important.
That's quite an indictment on us as members of society, and perhaps to a greater degree to the members of the media, who perhaps should make it their business to engage in constitutional education and related empowerment of society for the purposes of being part of in Parliament. The President is never going to charge himself, he's not going to prosecute himself, and he sure as hell is not going to sentence himself. So the question then is, if I'm reading you correctly, and this is a passing comment perhaps for your response later on, what is the residual obligation on those who have such obligations? And why is it, if they have obligations to do what I think you're suggesting they do, why are they not doing it? The President, in this regard, I think I'm going to use my time here to protect him. But I'm going to move on, and I welcome your response if there is. But there is a question of a trust deficit, yes, Sixolelo. And I think that's a theme that came through strongly in the closing remarks of Melusi. There's a trust deficit. Government is acting in an environment where the people for whom ostensibly they are acting simply do not trust what they do. That's why the conversation is taking place. And if you start engaging what has been happening and what continues to happen, current Chief Justice Raymond Zondo is at pains to even ask the questions, I have given you a report. Why does it look like this report is gathering dust? Among a host of things that we in society anticipate, if not expect to happen, do not happen. The Auditor General now is at pains to say, we are bleeding money. She's not the first one to be saying this. It's not the first time she is saying it. But there doesn't seem at all to be the requisite response to inculcate, perhaps, the trust question, which in my view, I put it to you, is moving in the wrong direction.
Is that working? Thank you very much, Songezo, for that, and thanks, Program Director, and thanks to the SABC for this invitation. Thank you, Chief Justice, for the lecture. For me, when I respond to the issue of trust deficit, I will allude to the scenarios that we had built. Unfortunately, we actually had Chief Justice Mogoeng Mogoeng, then he was Chief Justice, coming in to actually listen to these stories where we actually spoke to the matter of trust deficit. So it's not just within institutions. Again, I'll also reference my colleagues here, that this is about society as a whole. As South Africans, we do not trust each other, we do not trust our neighbors, we do not trust the government, we do not trust white people, we do not trust black people, we do not trust the foreigners. So there is this trust deficit that is quite endemic in society. And in our work, we've found that the history that we have has an impact on that. That we found that citizens have started displaying resistance to any efforts towards any form of reconciliation or any form of trusting institutions, because institutions are regarded as officialdom. So this thing has become so endemic, the resistance is there, but also what we found now, going back to the Chief Justice's lecture, part of this wrangling is over the Constitution itself, wherein South Africans cannot find each other. There are those who would say, especially young people, you would find that young people would point to the Constitution saying that it only benefits the elite, or those who are connected, or those who have funds to actually mobilize it and take it to the courts. But for the majority of our people, the Constitution is not valuable at all. Maybe every 5 years we'll get to vote.
Let me say this, just before you continue. Let me say this, because this was a question. Deal with this response. What makes us then claim, with a sense of legitimacy, that we have the world's leading example of a transformative constitution? Is the text the test, or is the effect and result and lived experience of that text the test?
To me, I would say the test is to the extent of our equality. Because we are so
Substantive
divided.
equality.
Yes, because we are so unequal as a nation. The way in which we experience the Constitution is on unequal terms.
So then we don't have a constitution of any value. There has been a lamented substantive inequality. Look at any economic indicator, it will tell you that, probably in more lamentable terms than the language I might deploy. Yet we have a constitutional text that promises all of these things that it does. But you walk outside right now, it's dark. I'm telling you, it's dark.
Well,
People are hungry. There's somebody who's going to meet you at the robots.
Agreed.
That substantive inequality cannot be then the basis upon which we now go proudly hailing our Constitution.
No, I agree. And I think that the test changed over each democratically elected government in place post the Constitution. At the point at which it was drafted, its progressive and aspirational nature was what gave it that title. It was heralded that from the interim Constitution on. But at each point at which I think it has been tested, I do believe it has come up short in realizing those values in its entirety and realizing it for everyone. I still never, and maybe as a constitutional lawyer, romantically not say it is a progressive and aspirational document. But whether we are realizing that, you have to be a realist about it, and we are not. I mean, that is clear. But I think in response, sorry, Malusi, in response to what Sis said earlier, the trust deficit, I believe, exists worldwide. Where you do not have in a homogeneous society, that trust deficit exists. We, of course, have an, I think, accentuated trust deficit through an added layer of, I think, colonial past plus apartheid. And then what has happened in the democratic dispensation, which has done very little to resolve the trust deficit, and if not, I think, entrenched more of it. And for me, we talk and we say in this, for me, it's just a long lament. And perhaps I'm now thinking of what to do about it. Where do we go with it? We were enlightened by the former Chief Justice with a focus on the presidency. And what now I would like to raise is happening next year in terms of an election. And whilst you just flippantly said, oh, we vote every 5 years, the number of voters that have voted since the first democratic election has significantly reduced each year. We are not accessing the power that we as the citizenry have at that most basic level. But in addition, and I'll let Malusi talk, there's a lot that the citizenry can do in and of itself. But that powerful tool, we're not using wisely.
Malusi, go ahead, your list.
There's a phrase that the former Chief Justice used, and that was us having to consider the constitutional system, whether it's something that we have to do. And I thought it was quite interesting. Why? Because, I'm sure many would argue that the Constitution is a viable document that is meant to be progressive in many respects and working. And in fact, when we talk about the contentious issue about land, perhaps there have been judgments that have been quite progressive. It's unfortunate, though, that our legislature, the people who are supposed to come up with laws or even implement some of these judgments, are actually behind times when it comes to it. They're still dilly-dallying about politics and figuring it out how to circumvent, right, the judgments, and to come up with creative ways to do so. So we will, at this point in time, it's hard to say that we've truly realized the best of the Constitution, given the socioeconomic issues that we have, and these are growing issues, but also more importantly, given that a very important arm of the state, Parliament, is doing little to actually advance the very same Constitution.
The time is 20 hours 28. You are listening to SAfm. This is Songezo Mabece in conversation with Kolelwa, Melusi, as well as Prelisha. We have just heard the wonderful presentation at the first and the inaugural lecture delivered by former Chief Justice Ndate Mogoeng Mogoeng. We're at that time now where we go to audience for questions. I have very, very little time, so I propose to take 3 critical questions from those who have pre-identified members of the panel to respond to that question. So please, can I see hands? And when you do ask your question, kindly confirm to whom your question is directed. It would either be to Kolelwa, Melusi, or Prelisha, and try and keep your question very short. Of course, we don't have the convenience of radio where we know who you are, where we can vet you. So I would kindly request you stand up, name, surname, organization if that is necessary, and pungently to your point. Do I have a first question from the audience and a roaming microphone to that? Yes, sir, please go ahead. That's 1.
Good evening, my name is Velim.
Apologies, just before you go ahead, apologies there. My colleague hijacked me there. Constitutionalism, order, comrade. Order, comrade. We just need to call on the Chief Justice, former Chief Justice, to please come and join us on the podium, on the stage, and then we can have the Q&A session that will take place. And as Songezo has indicated, please be as brief as possible with your questions as well as your commentary.
I beg your pardon, Eldrin. It was not me doing this out of disrespect, and I certainly do not want to be held in contempt in the presence of a former Chief Justice. So, well, ladies and gentlemen, the former Chief Justice is also somebody to whom you could pose your question. Of course, the rules don't change.
Good evening, my name is Velim Tiane. I work for the SABC News. My question is to the former Chief Justice. Is our Constitution a legal document or a political document? Thank you.
We'll take a second question before we go to the responses. Second question. Yes, the gentleman in front here with his hand up. Please go ahead, sir.
Thank you, Songezo. So my name is Mpanyana Tanjagwayo. My question is to the former Chief Justice. The views that I found the former Chief Justice expressed, especially around CR 17, are more at variance with what the courts have expressed. Why is that? Why there's no consistency? Why what the Chief Justice expressed now is at variance with what the court have said? Like, for instance, in the question of sealing the documents. And the Chief Justice is saying, we need to know.
Thank you very much, sir. Actually, let's take a question here in front. I'm going to take my executive authority and take the mic away from my colleague, Mr. Oliver Dixon, who's got more than sufficient a platform to engage. Not today, brother. Let's go, sir, in front, please.
Good evening, everybody. My name is Tulani Mteliz. On a Thanksgiving at Tembisa Hospital, Chief Justice Mogoeng Mogoeng, when praying, he cast the vaccine, purporting that it was embedded with 666 symbol. Were these utterances not compromising the partiality of the CJ office by standing against the resolution of the executive? Thank you.
I've got time to squeeze just one more question, but the Chief Justice is wondering, dear sir, the question that the Chief Justice is not quite clear, Do you want to repeat that very briefly, please? Use the microphone, of course.
When Chief Justice, on a Thanksgiving in Tembisa addressing the staff there, he purported that the vaccine is embedded with 666 symbol when he was praying. Were these utterances not compromising the partiality of the CJ office by standing against the resolution of the executive, which is another organ of state?
The comments that the Chief Justice made in relation to the vaccine and the 666 and all of those things, were they not a compromise to the office, more particularly against the positions of government? That's in essence the crux of the question from the gentleman, and he confirms by nodding his head. One final question, sir.
Yeah, thanks, facilitator. Good evening, Chief Justice and panelists. I am Tanduklo Nkala. I have a simple question for the Chief Justice. Chief Justice, I think when we have this discussion about corruption eroding our constitutional democracy, we tend to focus a lot on constitutional actors. And in doing so, it seems we ignore the fact that constitutional actors, in the main, are South African citizens whom we take from the South African society. We don't import constitutional actors. We get them from our society. And when they get into constitutional office, most of the time, they get there and they do all of these things that we complain about. The critical question I want to ask, because my argument is that more than the constitutional actors, the South African society is morally deficient. And I think Aldrin made the point about us and cold drink and South Africans. And we laugh when we talk about cold drink and cops, because it's been so normalized. And I want to ask, what can we do, Chief Justice, practically to morally regenerate the South African society? What must be done to make South Africa a moral society? Because by the time a person becomes a president...
I think the question has been made and posed. The commentary will come from the Chief Justice.
Thanks.
Former Chief Justice, please do respond. And I'm very mindful of the time. Aldrin has already wrapped his whip over my knuckles, and I don't want a second time of that. Can I ask for a 5-minute response, please, Chief Justice? Aldrin is next to you, and he will just tug on your suit. 5 minutes.
It's just that that was really my lecture in a rush. I had been warned to stick to time. The result was the flow that I would have appreciated to come out of the lecture did not come out. I said, quoting Chief Justice Pius Langa, regarding whether the Constitution is a legal or a political document, that we, in this constitutional democracy, you really can't draw an easy line between the law and politics. They are so intertwined, and I think Chief Justice Langa was right, that if you reflect on the decisions of the courts, you can easily mistake them for political documents. So it was a combination of the two. The Constitution is a product of both politics and law. Now, views expressed on CR 17 at variance, I was very careful to quote the judgments that I wrote, because those that know less often say that judges speak through their judgment. It's not true. I'm not here to deliver a judgment, but I was very deliberate to quote the judgment that I wrote on the CR 17 matter. It was a dissent. I did not finish it. The last part of it was, instead of the president addressing the truth that came out from the whistleblower, he then said, no, you stole it, to the public. You stole it. I said in that judgment, why are you not explaining why you had to hide this document? It was a judgment, sir. So it's a different judgment. I'm not just coming up with an address that is not in a court judgment. It is there, the public protector versus the president. So that answers your question. Tembisa, I never said any vaccine is embedded with 666. I think that's a problem with our nation. We just hear something flowing around and we don't take time to verify the facts. It was at the point when I was praying and I said, if If there is any vaccine that has the 666 effect, it must be burned. I don't know if prayer compromises the office of the Chief Justice. I think corruption and lies, lack of integrity, is what compromises any office, whether it is of the Chief Justice, the Minister, the President, or whoever else. I think the failure to be accountable, responsive and open when your office demands that you be so, is what compromises. So, my brother, as far as I'm concerned, you'll have to be a worshiper of something that kills for your prayer to compromise your office. The last one was what? Oh, yeah. Just remind me of that question. I can't even make out about the focus on constitutional actors. What was the question? What should be? Yes. Yes. Okay, I've got it. No, it's even worse. The focus in this country when we talk about corruption is on government officials. What's going on in the private sector? Why is it we hardly ever have a story running from January to December about corruption in the private sector? It is in the private sector we are being told about to address pay disparities. When people are earning hundreds of millions of rands and their employees are earning a pittance. Do we talk about that? I was talking to one of the SAfm people. I say, hey, you people hardly ever attempt to expose corruption in the private sector. I suppose that it is for the purpose of commercial breaks. Because they will not advertise in your media stations if you are going to be exposing them. And we are very soft on the cartels and the collusions that are damaging our country in the private sector. Look at the punishment that is often meted out to those who are damaging the economy, whether they collude about bread or whatever else. They are not exposed. There are always people available to come to their defense, to water down the effect of the corruption that is happening in the private sector. That is why the toxicities that have been dumped in the West Rand. I went to address a particular meeting, and some of the people in the mining industry were there. They were very happy I was there. But as soon as I articulated this irresponsible behavior and its harmful effects to society, the environment, including the animals, the people were so angry that they did not even see me out. I went to address another meeting about how communities from whose lands mining activities happen do not benefit from the huge sums of money that come from out of their land. I said, you people are not exposing this thing. When I finished, one journalist approached me and said, sir, all that you have said about the cover-ups, about social responsibility contracts that are not honored by those industries or some of those industries that operate in the rural communities is true. But you can't expose people in the private sector. I said, what do you mean? She said, I come from there. You expose, in the afternoon, your boss will be playing golf with that captain of industry that you exposed, and the matter will be buried, and be careful if your job doesn't get buried in the process. Who is exposing everybody? Until such time, I conclude, that every corrupt person is exposed in this country, corruption will never come to an end. As long as the focus is on people who are in government, but never on people who are in the private sector, forget about ridding our country of corruption. There is some game that is being played, and it's going to be worse when those in the private sector that are supposed to be exposed by those in government who are in control of the agencies that should expose them are the ones funding them. You can't bite the hand that feeds you, because come 2024, you must run for elections. You need money from them. And if you are exposing the wrongs that they have done, why should they support you? They must look for somebody else who will know his or her place. And that is the problem. As I said quickly in the speech, I think it is about time that, given the importance of this matter, that there is a budget, whatever number of billions from the taxpayers' pockets, that funds political parties, so that whoever wins at the end of the day owes allegiance to the one who, as usual, to the one who made it possible for him or her to get to high office. This time, it will be the taxpayer. You will never come across policies or legislations that do what, but where does this law come from? We are not like this. This does not advance our interest. Check who made it possible for that powerful person to get there. It's a problem all over the world. There is no free lunch.
A round of applause for former Chief Justice Mogoeng Mogoeng. Judge, I'm going to say this, it doesn't merit a response. We have a program, it's called SAfm Viewpoint. We have a segment there that we call the takeover. Oh my goodness, the judge says I twang too much. Judge, we have a show on SAfm that's called the Viewpoint Tuesday Takeover. You are more than welcome to come in studio, have a conversation to whoever about whatever. You can address these themes ad infinitum with all these persons in this room as audience to engage this further, because I fear the fact that time was always limited, it was going to be difficult for you to have the kind of reign you would have preferred. To my colleagues on stage, I'm going to give you 90 seconds each to literally wrap up this conversation. Sister, your thoughts very briefly.
Thank you, Songezo. For me, just in closing and maybe building on the Chief Justice's remarks on the role of business. And also when we started, we spoke about the whole of the citizenry. What is the role of civil society in taking things forward? Because some of these deficits, even when it comes to ethical leadership, they exist within civil society, they exist within business. But in taking the country forward towards a better trajectory, what can business do? Shouldn't we have a more activist business, purely based on our history and the benefits they reaped during our colonial and apartheid past? But also, what can you and I do in our everyday in taking the country forward? Thanks.
Very important question. Certainly your conscience has been kept alive there. Melusi, final comments, please.
I thought it was very interesting that the question about morality was raised. And I think when we think about morality, we need to think about it in the context of this society. We are a society where there are competing ideas and interests. Compared to other countries, they have set values, set spiritual values or religious values and so on, and they believe in a certain ethos. So what does it mean in a liberal democracy in South Africa? I think that's one of the things we need to think about, because our politicians will always talk about the rule of law, but how come they never emphasize morality? Right? So we need to think about those type of things. And as for the private sector, as my final point, I think it's important that we as society take on these particular topics in terms of corporate corruption, but not for the purpose of scoring political points, but for the purpose of actually understanding and addressing corporate corruption. For example, it's easier for people to talk about corruption in the corporate sector when it's a sexy topic. But dare I, for example, talk about land corruption that is happening in the Western Cape, and it's as a result of what's happening to farm workers, then all of a sudden middle-class people living in Joburg or even Cape Town or Durban don't really have an interest in that.
Fantastic.
That for me is hypocrisy.
Fantastic. Thank you so much, Melusi. Final comment, Prelisha.
Thanks, Songezo. The former Chief Justice left us on a bit of a cliffhanger there in relation to exposing of corruption. I wish to take that a step further. It's not just the exposing of corruption, it's the prosecution and the seeing of consequences. I harp on the word of accountability, but in improving society, we need to see people being held to account. That is when those behaviors will then, I hope, be deterred. I think then in relation to what we as a citizenry can do, both my colleagues on the panel suggested what is it incumbent upon us. And our relationship to government sits every 5 years. That is the most powerful tool that we as a citizenry have, and we don't even use it as effectively. Think about your vote, take time to investigate, and next year I hope that those polls are full, because that is when we can show our discontent as to what we as a citizenry have been experiencing.
Thank you so much, Ms. Singh. Thank you so much, Melusi. Thank you so much, Skolelo. I have been informed by the production team that I have to take this question in the context and in line with this month being Persons with Disability Awareness Month. There was a question posed from the floor at a time at which the gentleman did not have a microphone. His entry words were, "This is unfair." And in the context of fairness, let us correct an ostensible unfairness. Sir, I apologize if in any way you felt offended by the proceedings of today, but nonetheless, you have the microphone on air to the nation. Put me in my place.
Thank you so much, former Chief Justice, Mogoeng Mogoeng. Chief Justice, do you really think that the South African government is really respecting the rights of persons living with disabilities? Because in most cases, we're always excluded in everything. Like for an example, as I am a blind person, I'm excluded from different learnerships. I'm excluded from internships. I'm excluded from permanent employment. One of my friends received a letter last week. That letter was saying that we cannot employ you because of your disability, the nature of your disability. Resources are very expensive, of which is totally wrong, the former Chief Justice. I'm not saying, maybe, not saying you failed us, former Chief Justice. But I must state it, Chief Justice. Former Chief Justice. Ki feel like government are failed or irrefailed. You about what as persons who are living with disabilities, especially totally blind people. So my question is very straight and simple and straightforward, former Chief Justice. Do you really think our South African system does it favor us, persons living with disabilities? I submit.
Thank you very much, sir. I appreciate the question. It is an important question. Aldrin, I really do not do what I do out of contempt for your work and your authority. Chief Justice, could we get a very brief response, please, to the gentleman's question? Here is a microphone.
What I have seen, for instance, with my colleague Justice Yakub, who is blind, and I know there is also another judge, Justice Yakub, notwithstanding the fact that he had a disability, rose to be in the highest court in the land, and at some stage was actually the acting Deputy Chief Justice of the Republic. I know that there is Minister Buhopane as well, who is a person with disability. Maybe what you could do, my brother, to understand what other opportunities might be available that you're not aware of, is to have this man, I'm committing Songeso because he used to work at the court, to link you up with Justice Yakub. He's a kind-hearted man, a very caring man, and see if he would not be able to advise in a manner that you and others could be assisted. I'm aware that there are some government programs, and it may well be that one of them would just be the right one for you, or a way could be paved for you to get to where you need to go.
Thank you so much, Chief Justice. Thank you so much, Aldrin. My brother, thank you very much for honoring me as you have. Take care of your program.
Ladies and gentlemen, another round of applause to our guest lecturer as well as the panelists. And thank you so much for the contribution as well. I think it was a success, yeah? I think it was a success, considering how many hands were up, and all of those hands, unfortunately, we couldn't get to all of them. But I think, indeed, it was a success. A lot of questions that have been raised and a lot of issues that we still need to discuss. And also, what does transparency really look like? What does transparency really look like? I don't know if I can steal this moment, Chief Justice, former Chief Justice. When we announced that we're going to have this lecture, the public lecture, one of our listeners responded with this tweet, and he speaks about the 600 million rand, former Chief Justice, that you spoke of. And he then says, when are we going to know who exactly this person is who offered this 600 million outside of just this person being an American billionaire? Do you have a moment now, former Chief Justice, to answer that question?
So is the person asking that I disclose the identity of the person?
Yes.
No, I won't. I'll tell you why. A colleague of mine that I respect highly, unsuspectingly, came to my office on behalf of that person to make the offer. I would have to expose my colleague who meant no harm, who just wanted to assist the court. By the way, it was not for my personal benefit, although the funder apparently said, I can use it in whichever way I want, I don't have to account. But because I knew this man and what harm he has reportedly done to a number of countries, even in Europe, I was annoyed to the point where I did not even respond to my colleague. I never went back to him. He's the man who even sponsors marches, from what I understand.
Who is this
He can have people march out of government.
Who is this American billionaire? Who is the American billionaire? We're going to keep on finding Mimo, right? The American billionaire is Mimo. We've come to the end of our discussion. Once again, thank you so much for being part of the discussion that we had today and also heeding the call. I'm going to call onto the podium now our closing remarks from the business manager for the Fortune Combo, that is Mr. Anthony Soglo.
Wow, what an evening. Very good evening to everyone who's here this evening, and all protocol observed. To the former Chief Justice, very good evening to you, sir, and thank you for the past 3 hours you've spent with us. I'm enormously honored to stand before you here today on behalf of the SAfm team, our staff as well as our talent. This has almost been a culmination of a whole year of planning, believe it or not. This all started from a phone call that I made to our marketing manager last year around August, where I had a session when we were planning our strategy session for this year. And I asked him why a leading brand, national talk station like SAfm doesn't have a property like a lecture to not only put us above all our competitors, but at the same time, intellectually give off to our audiences as well. So the idea of hosting a public lecture was then born through that. We then included it in our strategy document. We presented it to our radio management last year. And I must say, our management was very excited about us putting together this lecture. Once approved, the next step was to establish a topic that would affect us all. Whether you are from Northcrest, Mthatha, like I am from, or you're from Alabama in the Northwest, or in the richest square mile on the continent, upholding the rule of law is something that affects us all, in one way or the other. And once we came up with a topic, naturally the next step was for us to find out who we can have to deliver this lecture. I must say we had a number of names, but we kept on circling back to this particular name. Sometimes we would go, okay, fine, let's give it a couple of weeks and come back, but we would circle back and come back to this particular name of the former Chief Justice. And I must say what she's delivered here today really emphasizes the reason why we could not get away from that name. It was almost as if he was coming to us in our meetings to say, hey guys, I'm going to be the one to deliver this lecture to you guys. And we're very much honored to have the Chief Justice deliver the lecture for us today. As we made the decision to invite the Chief Justice, we subsequently got named the South African PBS radio station of the year. And we sort of saw a link there. So I think what's going to happen now is that we're going to invite the Chief Justice every year to deliver our speech so that we can be the station of the year every single year. So Chief Justice, this is an executive decision I'm taking, guys. We're going to have the Chief Justice every year deliver our public lecture. I must say, in 87 years of existence of SAfm, we have started something new, which is this. Which I was saying earlier on today, it just shows that you're never too old to start something new. The station is 87 years, we've never had a public lecture, but for us to do it in the 88th year, and in the year where we are the station of the year, we're extremely proud of doing this. In the next 3 weeks, SAfm will be launching a new brand campaign. Our tagline is leading the conversation. Now, in our 88th year, we want to position ourselves as a station that leads the conversations that matter. So we're moving from leading the conversation to leading conversations that matter. Those two words are so important to us as a brand. So you'll be seeing a lot of that as we move forward. I think if we were to encapsulate what the Chief Justice was saying today, it's all about having conversations that matter to us in our daily lives. And so we are extremely, extremely proud and honored for us as a station to be having that brand campaign, which is going to be leading conversations that matter. So whether it's on an economical front, social front, political front, micro or micro environments, we need to ensure that we all lead the conversations that propel us forward in our own environments. The words of the Chief Justice today has really convinced myself and the team that I think we've made the very right choice to have him being the first person to deliver our inaugural lecture. SAfm is extremely honored to have you, sir. And I think the only problem now we have is to find out who will top this for next year. But I think, as we've said, we'll have you next year as well, so that is not going to be a problem at all. On behalf of the station, on behalf of my management, Shweshwe, who's our program manager, Randy, who's our marketing manager, who leads the team. I know this past couple of months and couple of days leading to this hasn't been very, very easy. The late calls you've been receiving from me to ensure that we get this right is one that I'm extremely proud of. Thank you very much, but most importantly, I want to thank you, our listeners, our stakeholders, our partners. We wouldn't be anything without you. And so from the station, on behalf of the station, would like to say a very, very big thank you to you for being with us tonight and also being our stakeholders at SAfm. With those words, I'd like to say again, thank you very much, and I'm going to hand over back to Mr. Aldrin. But before that, I think a special thank you must go to our radio management. I think when we mentioned the name of the Chief Justice, hey, that guy's robust. Eh? We know he's very robust. And we had a couple of long nights about it, but I think there's nothing that we can take from what he has said. It's really about us having those conversations within our spaces. So again, Chief Justice, really, really proud to have you deliver our very, very first lecture. And I'm certainly sure we're going to have you here again. To the team at SAfm, thank you guys very much. To the team at the other stations for helping out as well, thank you very much. And also to our technical guys. I know our big boss is going to come and do the vote of thanks shortly, but that is just one that I wanted to just say. Thank you very much, Aldrin. Cool.
Former Chief Justice, I have to say that I'm really happy that my boss, Anthony, is also happy, because that means that the issue that you were speaking about earlier on, that salaries and what, you know, please do come again. We are now going to call on the Group Executive for SABC Radio, Nada Wochela, to come and give us a vote of thanks.
What a beautiful evening. Ladies and gentlemen, good evening. I must say, we're all very happy. This evening turned out to be everything we had hoped for and more. To our guest of honor, former Chief Justice Mogoeng Mogoeng and your beautiful family, what an honor to have you accept our invitation and kickstart our public lecture series. Thank you, sir, from the bottom of our hearts. Our board chairperson, Katu Ramukumba, thank you for your support always. Acting Group CEO of the SABC, Mr. Lungile Binza, and EXCO members who are present here today, thank you, colleagues, for always showing up for radio and our audiences at large. Mr. Alistair Slingers from the Constitutional Court, who is also the Director of Executive Support, who was quite instrumental and leading the engagements with the station on behalf of the Chief Justice. Thank you, sir. Our esteemed panel of discussants, Malusi Ngala, Pralisha Singh, Head of Practice at Weber Wenzel, Xolelwa Kashe Katia, Project Lead at Indulamiti, Director General of Department of Justice and Constitutional Development, who's, Advocate Dr. Mashabane, who is accompanied by his colleagues from the Department of Justice, Advocate Lloyd Lotz, and others. CIU's Mr. Kaiser Khanyago, Head of Stakeholder Relations and Communications, and formerly of SABC, may I add? We still love you, Kaiser. President of the Black Management Forum, Ms. Mongile Vilakazi, civil, social, and legal organizations, and academia, SAfm stakeholders, our clients, our partners in public service, thank you so much for joining us this evening. To SAfm management and staff, thank you, colleagues, for relentlessly driving the public mandate of the SABC and for not backing down when we say there is no money. And also for guilt-tripping us, by saying the Chief Justice is available. Who can say no? Indeed, who could say no? Our support staff, from technology to corporate affairs and even our protection services staff, thank you for playing your part in making this event the success that it was. It's only when we work together like this that we win big as the public broadcaster. Our program director, Aldrin Sampier, I'm not sure about the salary, and the discussion facilitator, Songezo Mabece, a big thank you to you, colleagues. SAfm listeners who joined us in person here in the auditorium, those who listened on the radio and those streaming on our social media platforms and SABC Plus, thank you for sticking with the station, through thick and thin. We continue to celebrate SAfm as the national leader in talk radio and the current PBS South African Radio Station of the Year. In its 87th year of existence, this station is not done. Sorry, Metro FM, I had to borrow your line. We look forward to delivering more engaging, insightful, and thought-provoking public lectures in 2024 and beyond. Have a good evening and drive safely.
Okay, we are now going to call on Mr. JVR, our GM radio, to hand over this certificate over here to our former Chief Justice of the country and, of course, our first ever guest lecturer, Mogoeng Mogoeng. So right now we have there's the cap. The cap looks good on you, former Chief Justice. It really looks good on you. We want to know what's inside the bag as well. Transparency is important. You know, want to make sure that there are no brown envelopes here. 600 Okay, thank you so much, former Chief Justice. I'm now going to call on the marketing team to please come forward and hand over a token of appreciation to our panelists as well. And they are also getting a hamper that is in a paper bag. It must be intentional, former Chief Justice, that there is a hamper that is not transparent. Next time, I think in the interest of transparency, can we have paper bags that are transparent as well, like plastic paper bags, please, 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 so that everyone can see here that we play clean. We totally play clean here at the SAVC and at SAFM. By the way, we will be handing out 600 million rands. We will be handing out 2 parcels as well, token of appreciation once again to people in the audience. I don't know, who should I get to come and ask a question? Let's see. Okay, but I need you to ask a question from the audience, and then we decide whether the person wins. Okay, we've got a hand there at the back. Can we quickly?
St. Pierre was interviewing me on Power FM one day, and questions came flocking. Why don't you run for president? When the program ended, this man said, Chief Justice Mogoeng Mogoeng for president. On air. I have no ambition to become president of this country. It may never make sense to you, but it's a call, it's a calling. Whether you believe it or not,
is going to happen and your mouth will be left open.
And as I said before, in whichever form it happens, it's not going to be through a political party, by the way. Once again, ladies and gentlemen, thank you so much for attending our inaugural public lecture. SAfm really wants to express its gratitude to its listeners, to our various stakeholders, and for you to come out and come and have this evening with us. There is refreshments that will be served right outside the venue. Thank you so much and have a beautiful evening. Tot ziens.